The dying declaration is one of the very strong type of evidence that we are going to study here. So another thing is like the next circumstance I am going to explain today. If suppose the dying declaration is an incomplete statement given by the person who died just before his death, he was giving the statement, and the statement was actually with regard to the dying declaration only. But unfortunately, before he could complete his statement, suppose if he died, can you consider this as a dying declaration? The question arises here. The basic condition is that dying declaration must be complete. If it is incomplete, generally that cannot be accepted as a dying declaration. Suppose if the main facts, the important reason of the death, or the proper circumstances which caused to his death have been explained, and some of the final question, if it is not answered, because of that final question is not answered, we cannot give up the importance of dying declaration in the evidence. That means it is applicable. The next thing is that dying declaration, if it's having some kind of detrimental statements from one dying declaration to another dying declaration. Say for example, if he has given two different statements in front of two different persons, then what will happen? Then the main thing is that if there are discrepancies, or if there are kind of contradictions between one statement to another statement, in that case the dying declaration will not be made applicable. That cannot be trusted, and solely on the basis of such kind of discrepancies or inconsistent statements, accused cannot be punished. And another important thing is that absence of medical statement of fitness certificate, or statement of the doctor. If the doctor has not given a certificate with regard to fitness of the accused, victim. Here the fitness, mainly we have to discuss two fitnesses. One thing is physical fitness, second one is mental, the psychological fitness. Physical fitness is also important actually, because the sound mind is always there in the sound body. If the body is not sound, then obviously it will affect the mind also. That's why if the doctor has certified that this person is fit to give declaration, or to give an independent opinion, then because of that certificate, dying declaration will become genuine. Suppose in some cases, if the dying declaration, at the time of dying declaration, the victim was not certified by the doctor whether he was fit to give or not fit to give the dying declaration. In that case, merely because of absence of such a certification, dying declaration cannot be given up, unless the circumstances are so self-evident to explain that this particular situation was not good for the victim to give the proper or independent dying declaration. So that's why medical document is important, medical fitness certificate is important, but it is not that much important which can even evaporate the dying declaration. That's why it can be, but it may not be that much important. That we have to understand. The next thing is that the doctor's statement, if say for example, the doctor has written himself the dying declaration, whatever he says before the court of law, being a witness who has recorded the dying declaration, it has to be trusted by the court. Merely because he is a doctor, he has treated the witness, we cannot doubt the genuineness of the statement given by the doctor. If at all such statement is including unbelievable sort of allegations also, they have to be taken seriously by the court, unless and until there is a contrary admissible evidence is placed before the court cannot give up the doctor's statement given in the form of witness to the dying declaration. In case of dowry death, it is one of the crucial point we are going to discuss today. In one case, what happened, a woman after the marriage, she gave a statement to her relatives telling that in her in-laws house she is having threat to her life. After giving this statement, almost after 4 to 5 months, she died in a very suspicious way. After her death, her parents filed a complaint telling that it is a dowry death case. What happened in this case was, Court considered 4 months old statement given to the parents that she was having the threat to her life. The statement was actually given in the form of letter written to the parents. That's why the proper evidence was available with regard to existence of the statement given by the victim. When the victim's statement was properly available in the court of law, court did not feel the necessity of giving up such evidence. That means in that case, the dying declaration was admitted even though it was given 4 months back. That time she was actually having threat to her life from her in-laws. That was the statement was given. Because of the statement, that all the in-laws were convicted in that case. So it is possible that dying declaration need not be immediately before the death. It may be much prior to the death. That can also become a dying declaration. Statements made to or implicating relatives. Merely because some close relatives are implicated, we cannot doubt the validity of dying declaration. Similarly, if the dying declaration is telling that these relatives have heard telling the dying declaration, means the dying declaration was finally heard by close relatives. Because only close relative have heard, the dying declaration will not lose its validity. That means whoever have heard it, the importance of the dying declaration will be intact. But again, there are grades. Which dying declaration is most trustworthy, which is lesser trustworthy? There are some grades. Those grades are like very simple. The first one is, if the magistrate, either judicial magistrate or executive magistrate, if they have recorded the dying declaration, the genuineness, the trustworthiness of the dying declaration will be much more than any others. Then comes police officers. If, because they are experts in the evidence, they are actually trained in the evidence, that's why if the police officer has recorded the dying declaration, that also will be considered as important. And in between both, the doctors, the person who has treated the victim before the death of the victim, if victim told at the time of either admission or at the time of treatment that this injury or this particular situation of his death was actually caused by so and so persons, that dying declaration is also having much importance. Rest other dying declarations actually which are recorded by the common people who are not having that much knowledge in the recording of dying declarations, that can be trusted, but not comparing to the, as I told earlier, they are more trustworthy. This one is the lesser trustworthy. So after understanding this, we came to know that dying declarations which are important and which are not that much important, which can be trusted, which can be lesser, the quantity of trust will be lesser in some of the dying declarations. Statements made evidentiary value of dying declaration. Any statement which is made as a dying declaration, what level of evidentiary value it will be having in the court of law? That's the question here. The main answer is that if the dying declaration is given solely on the base of dying declaration, conviction is possible. That means this piece of evidence is very, very important, and it is independent evidence. It need not be always relying upon other corroborative evidence. If at all the strong and believable statement of dying declaration is available, then court need not to wait for any other evidence. Court can go for conviction. That's why the evidentiary value of dying declaration is almost most important, we can say, comparing to the all other sorts of relating facts or relevant facts in the Evidence Act. This particular dying declaration is the most relevant fact in the evidence. But very importantly, we have to take another side note or note which is running along with this particular importance of the dying declaration, is that dying declaration is also subjected to the cross-examination. Until and unless cross-examination of the person who is giving the witness of dying declaration before the court of law, it cannot be trusted. That means that person who is giving the witness of a dying declaration is subjected to the cross-examination. Unless there is cross-examination, we even cannot trust this dying declaration also. In Kushal Rao versus State of Bombay, the Honorable Supreme Court laid down some following principles related to dying declaration. there are some important principles. Those principles we will study one by one. There are some 5-6 different principles have been laid down how and what extent the court can give importance to the dying declaration. The main thing is that there is no absolute rule of law that dying declaration cannot be the sole basis of conviction. That means only on the basis of dying declaration conviction can be given. That's a point number 1 given by the Supreme Court. Second point, the dying declaration is not a weak kind of evidence. Means it is a strong evidence. It is not a weak kind of evidence. That's why this evidence is always more trustworthy in the court of law. The third point is that each case must have to be determined with its separate facts and circumstances. That means one case will not be completely based upon another case. If the dying declaration in one case you have recorded, you have studied, that doesn't mean that the same dying declaration if come in other court, other case, you have to go for the same judgment. No, you have to analyze that particular case independently, isolatedly, without having prejudice in the mind of any other case. So importantly, we have to concentrate on facts and circumstances of each and every case separately. So next one is that dying declaration stands on the same footing as the other piece of evidences and has to be judged in the light of surrounding circumstances. Like other sorts of evidences what we are actually taking in the court, this dying declaration is also equally important, but equally it is subjected to the surrounding circumstances. It has to be judged along with the surrounding circumstances. The next one is that a dying declaration which has been recorded by the competent magistrate in the proper manner, that is to say that in the form of question and answers, as far as practical, in the words of the maker of the declaration. That means if it is also have been recorded in the form of question and answer model, the magistrate has to, as far as possible, has to write these dying declarations in the same manner and the format which is actually told by the declarer. These are very important points which were laid down, as I told you, in a very important case, that is Kushal Rao versus State of Bombay, Supreme Court. We have to follow these instructions of the Supreme Court to understand the basic tenets of dying declaration. Some of the exceptions are there. Those exceptions I have recorded one by one, I have listed here. You can make note of it. The exceptions of dying declaration stipulated that where the statements made by dying person are not admissible in these exceptional circumstances. If the cause of death of the deceased is not in the question, if in any case the main person who gave the statement, his death is not in question, but some other person's death is in question, in that case, this cannot be considered as a dying declaration. It may be considered as a piece of evidence, that is hearsay evidence, but it cannot be considered as dying declaration under section 32 clause 1. That's why this importance of dying declaration will not be attributed to the case where the statement giver's death is not in question. The second one is that if the declarer is not a competent witness because of his unsoundness of mind or because of the unsoundness caused due to the accident or the injuries. Say for example, in a burning case, if 80% or more, 90% or more body is burnt, in that case due to the severe injuries, the person may not be having a sound mind. That's why whatever opinion he gives, that cannot be considered as an independent opinion. That's why this dying declaration will not be admitted in the court of law as dying declaration. The next exception is that inconsistent declarations. I was explaining just before that when there are two or more different dying declarations, if they are having some inconsistencies in between, those inconsistent statements cannot be considered, and all of such statements will lose their evidentiary value. Doubtful features. If the dying declaration is recorded in such a circumstance, that circumstance itself has created certain doubts in the mind of the judge, that doubt is sufficient to disbelieve the dying declaration. Next one is untrue declaration. If any part of the statement or the complete statement is believed by the court with proper reasons that it is untrue, if it is possible to separate that untrue part from the entire statement, court can separate it and rest of the part can be taken as an evidence. If that particular part cannot be separated, then the entire statement given by the victim will become untrue, and that cannot be completed, that cannot be taken as dying declaration before the court. The next one is incomplete declarations. If the declaration is incomplete, then also it is not applicable as a dying declaration. If the statement relates to the death of another person, then also it is not a dying declaration.